Okay, so Mr. Kenyon is here. You want me to bring him in?
Yes, please. Thank you. Good morning, Officer Montoya. How are you?
Good morning.
Good morning, everybody. I'm good, thank you.
Couldn't get started. Good morning.
Morning, Mr. Kenyon. Sorry. Good morning, Mr. Kenyon. All right, it is 9 o'clock, so we can get started, okay?
I'm here.
All right. All right, so good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Paula Kenyon, inmate number 076914. Today is Friday, July 24th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Paul Kenyon, 76914.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Kenyon.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
Officer Montoya, Waterbury Parole Office.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath, so Mr. Kenyon and Officer Montoya, can you both please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Yes.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings, and if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will then have the same opportunity. Mr. Kenyon, do you have any questions about the purpose or procedure before we begin?
No, ma'am.
All right, so we will review your rights for today's hearing. So the first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive a written notice of charge of the violation. Did you receive that written notice?
Yes, ma'am.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
And we will now review the charge that the state, your parole officer, is bringing against you and the information underlying that charge. So, Officer Montoya, can you please review the charge for us?
Sure. Charge 1, obedience to the law. On 3/6/2026, Waterbury police officers were called to Pixa Castle, located at 143 Chase Avenue, on a report of threatening. It was reported to Waterbury police that you came into Pixa Castle restaurant and created a disturbance. A witness reported that you attempted to touch your ex-wife. When she refused your touch, you stated, "The only reason I won't punch your mother in the face is because you are here." When the witness tried to defend the victim, you stated then that you were going to shoot the victim and the witness. You were subsequently arrested and charged with threatening in the second degree, breach of peace in the second degree.
Thank you. You've also submitted evidence in support of the charge. Can you please identify the evidence for us?
Sure. Remand to custody order, parole conditions, parole violation report, notice of parole violation, decision information summary, preliminary hearing summary dated 1/22/2022, revocation hearing summary dated 6/9/2025. Waterbury Police Report number 26-19302. Judicial pending case detail.
Thank you. And you've also submitted an addendum to the parole violation report. Can you please review that for us?
Sure, hold on.
No problem. Take your time.
Montoya?
I'm in a hearing right now.
Oh, okay, sorry, bye.
The addendum. On June 24, 2026, Kenyon Paul 76914 appeared at Waterbury Court under docket NO UO 4W-CR26-051-8397-S to face the following charges: breach of peace, second degree, and threatening physical threat. And breach of peace, second degree. Okay, hold on a second. He had two charges: breach of peace, second degree, and threatening physical threat. The breach of peace degree charge was nully, and Kenyon pled guilty to threatening physical threat and received 6 months jail time.
Perfect. Thank you, Officer Montoya.
Sorry for the confusion.
No, you're okay. Thank you. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have.
And we did receive one exhibit from the defense. We have the list of accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
We do not, thank you.
We do not have any witnesses, so at this time, it is the state's opportunity to present evidence and speak to any of the evidence submitted and the charge in front of us. So Officer Montoya, any comments at this point or statements towards the charge?
Truthfully, I don't know Mr. Kenyon that well. He was with me for maybe a month. He was just transferred to me when this incident took place. And I believe I only met him once. During the time that we met, he was respectful and he, we had a good, amenable conversation. We were talking about what his discharge plan was going to be. No, I really, I received the call from the police. I had to fax the remand, and that's really all I have to say about it. I am not that familiar with his case, just to be honest.
Okay, thank you, Officer Montoya. And counsel?
Yes, thank you, P.O. Montoya, for putting that on the record. I do appreciate it. As to the charges, I would just note that the matter was resolved in court. My client received 6 months flat to serve, no additional supervision to follow on the one misdemeanor charge. The breach of peace matter was nollied. I would just note concerning my client's version of the facts, we aren't contesting the fact that there was a conviction here. However, I do just want to note he does disagree with the facts as they're indicated in the report. He reports leaving the restaurant that day thinking everything was okay and was surprised when he was later arrested and these allegations were made. However, being that he is on discretionary parole and was effectively serving dead time on the matter until it was resolved, he did elect to accept a plea agreement rather than having to wait a lengthy period of time to go to trial. But those are my comments for the charge. I would like to speak to his background and history at the appropriate time. Thank you.
Thank you.
Let's see, another guy got. He had no permission or authorization to dance through.
Take a quick moment and then I will announce my finding.
I wanted to add a little something, if may I add? A little something?
Absolutely.
I did review Mr. Kenyon's case, and although I didn't have like a long-standing history with him, in reviewing his case, I do know that he has poor impulse control, as evidenced by his prior revocation that he had before. I do agree that he's almost done with it this time, and I'm not opposed to him being released back into the community so he can do a good discharge plan while he's out in the community. It is better for him as well as for us, instead of just, coming out of the facility with nothing. I think I am open to him being released, whenever you find it amenable. But I do want to put on record that Mr. Kenyon, you do at your age should really control yourself better and have more of an impulse control. And you know that you have an adverse relationship with these parties. You should have just left the restaurants with no, interaction with them, and this whole thing would have been avoided. So this goes back to you really just thinking back and think before you act. That's all I'm going to say, okay? Thank you.
No, Council, anything?
Nothing further, thank you.
So on charge number one, Mr. Kenyon, I am finding that you violated that condition based on the evidence, based on your conviction of the threatening second on June 24th, when you received that 6-month sentence. In addition, the evidence in support of the charge just states exhibits B, C, H, and I. That does conclude the fact-finding portion of this hearing. Before I do make my recommendation, the state will have an opportunity to present any other testimony towards your background history if they choose to do so. And then you will also have that same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So Officer Montoya, anything additional at this time?
So I will, like I said, I am definitely open for him to be released. I think he's been in enough, when they do the time calculation, if he's, if he's able to come out, I'm okay with that. I will ask that he had a no contact stipulation with the victim that was identified in this case. I'm not against him maybe doing some domestic violence, a little bit of counseling in that sense, but that's really it.
Thank you. And counsel?
Yes, thank you. My client is 66 years old, born and raised in Waterbury. His support in the community includes his sister, Dr. Lott, his close family friend, Miss Sotwell, and his 6 adult children, majority of whom do reside in the area. He also reports having 15 grandchildren and 4 great-grandchildren, and he did tragically lose his 7th child, which was his son. Most recently, upon release to parole in August of 2025, my client successfully completed Renaissance Central. He then utilized the REACH program at a residence in Waterbury, where he remained until remand. Previously, he has a history of successful completion of Chase Center and utilizing Chrysalis Center's scattered site program. Most recently, he was approved for Social Security disability for mental health purposes. Previously, he was employed full-time for precise traffic control in Waterbury. Concerning treatment, in March of 2026, he completed successfully IOP, relapse prevention, CBT, and DBT groups through Wellmore. He also was doing CCAR for added support. Upon reinstatement, he's open to a halfway house placement in Waterbury, Connecticut. He does have a history of successfully completing halfway houses in that jurisdiction. He does hope to enroll in a cosmetology program to officially obtain a barber's license. He does have prior experience cutting hair and has obtained the required hours. He does plan to complete the recovery coaching program. He really wants to give back and help other individuals struggling with addiction. He also is hoping to reactivate his disability services. He reports having the ability to work part-time up to, I believe, 20 hours on his disability, and is going to explore an opportunity through Burger King, but is open to any sort of opportunities out there. And he's also open to any sort of treatment recommended, and is very eager to reestablish services at Wellmore because he did have a very good relationship with the folks over there. I am asking that you would consider releasing Mr. Kenyon on the earliest eligibility date for the new sentence. He has been incarcerated for approximately 4.5 months. In that time, he's had no disciplinary reports. He has had none in the last 10 years. He also was issued no misconducts that I can see on this period of supervision, and was doing relatively well. Thank you.
Thank you. Just want to take a moment, then I'll announce my recommendation.
Thank you. Mr. Pinion, is there anything else you want to say, or you're all set? Okay. Thank you very much. Thank you.
Appreciate it. Appreciate it, Ms. Montoya.
So I've listened to the testimony today. I've also reviewed all the evidence presented. I do just want to note on the record, Mr. Kenyon, this is your second criminal violation on this term of discretionary parole, so that is concerning. And as Officer Montoya commented, it seems like your impulse control is something that you need to work on. The earliest date that you would be eligible to be released is September 23rd, 2026. That's your parole eligibility date because of the new sentence. And your current end of sentence I have is December 23rd, 2026. This was a criminal conviction, another 6-month sentence. So Mr. Kenyon, I'm gonna recommend that your parole be revoked and that you receive no new re-parole date. So that is an approximate 9.5 month sanction. In the event the board decides to lessen the recommendation, I'm gonna recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, a general no contact with Shira stalling, no contact with victim DL, no contact with victim TL without parole officer's permission, and halfway house placement. So what happens next, Mr. Kenyon, is that my recommendation is gonna go to the board on August 6th. On that date, the board can do two things. They can lower the recommendation. The only date they can give you, or the earliest date, is September 23rd of 2026. They can pick any date between that and your end of sentence in December, or they can adopt the recommendation if they choose to do so. So that does conclude today's hearing. Do you have any questions?
Oh, ma'am.
So this does conclude the revocation hearing for Paul Kenyon, inmate number 076914. I also want to note on record that you do have probation to follow, correct?
Right, I believe
At
3
3 years?
3 years, I believe.
Sorry, so I do just want to put that on the record as well, that you do have probation to follow this sentence when it expires in December. So it does conclude the hearing for Paul Kenyon, inmate number 076914.
Sir, if you have any questions, feel free to ask your counselor to set up a call with my office, okay?
Okay.
All
Good
right,
enough.
thank you very
Good luck
much.
to you, Mr. Kenyon.
Thank you, everyone. Thank you, PO.
Thank you, everyone.
Thank you, Officer. Have a good day.
I clicked accept. I clicked it.
Hi, good morning.
Good morning. I can't. Oh, I can see now.
Awesome. So Ms. Pina, it is 9.
I'm sorry.
That's okay.
I have to get my papers.
Oh, yeah, absolutely. It's 9:25 right now. We can't start until exactly 9:30. So in about 5 minutes, we'll get going, okay?
Okay.
Good morning, Officer Saunders. How are you?
Good morning. I'm doing well. How are you?
Good. So we can't start until exactly 9:30, so we'll get going in 3 minutes, okay?
Okay.
Good morning, Attorney Jones.
Good morning.
Good morning, Ms. Pina. Good morning.
Attorney Jones, you did see my email about Mr. Payson later today? I'm not gonna log in to the facility or anything like that.
No,
You
I
did
didn't
not.
see it, but I'll take a look.
Okay, so you don't have to log in. I'm just gonna announce on that live stream that you waived it, unless you want to be
Okay.
there, but I called.
No, that's
for
fine.
For him to not be present.
Yeah, that's fine. Thank you.
Thank you. All right, and now we can get started. So good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Brianna Pina, inmate number 386312. Today is Friday, July 24th, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in North Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Brianna Pina, 386312.
Thank you. So this is a revocation, This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones on behalf of Mrs. Pina.
Thank you. And also present is your charging officer. Can you please identify yourself for the record? Yeah. Sorry, Officer Saunders, I didn't hear you. Are you?
We can't hear you.
Yeah,
Parole Supervisor Saunders with Parole and Community Services.
thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Ms. Pina and Officer Saunders, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yes.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will then have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will then have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay, we'll now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So Officer Saunders, can you please start review the charges for us, starting with number 1, obedience to the law?
Yes, charge 1, obedience to the law. On 4/16/2026, you were admitted into the Rise Residential Halfway House. You signed and acknowledged the receipt of the Residential Provider Handbook and signed the Halfway House Agreement. On 5/12/26, a room search was conducted of your assigned bedroom, which resulted in findings of what appeared to be illegal contraband. Contraband identified as a glass pipe with burnt end, 2 unidentified pills, empty pens containing unknown powder substance. Connecticut State Police responded to the Halfway House for further investigation. At the conclusion of their investigation, you were found in violation of Connecticut General Statute 21A-279, possession of a controlled substance, and 53A-174, conveyance of unauthorized items in an institution. On 5/13, you appeared in front of a GA-23 judge and arraigned on both charges under docket ending 952-S. This is direct violation of your special parole conditions to obey all laws. Charge number 2 is drugs. On 5/12/26, you rendered a positive toxicology screen for cocaine. Charge number 3, additional condition, halfway house placement. On 4/16/2026, you were admitted into the Rise Residential Provider Program. You signed and acknowledged the receipt of a Residential Provider Handbook and signed the halfway house agreement. On 5/12, a room search was conducted in your assigned room at the Women's Rise Halfway House, resulting in findings of what appeared to be illegal contraband. contraband identified as glass pipe, burnt end with burnt end, 2 unidentified pills, empty pens containing an unknown powder substance. Connecticut State Police responded to the halfway house. Responded to the halfway house. At the conclusion of their investigation, you were found in violation of Connecticut General Statutes 21A 279, possession of a controlled substance, and 53A 174, conveyance of unauthorized items in an institution. This directly violates your halfway house agreement to not possess vape pens inside the halfway, take prescribed medication as directed, and not bring drug paraphernalia into the program.
Thank you. You've also submitted evidence in support of the charges. Can you please identify the evidence for us?
Yep. Exhibit A, signed statement of understanding agreement conditions of parole, remand to custody order, notice of parole violation and parolee rights, parole violation report, women's rights incident report, photo of the contraband found, Connecticut State Police Troop I arrest report 26-151611. Connecticut Judicial Branch pending case detail for docket ending in 952-S. Women's Rise Program Resident Handbook Acknowledgement. Halfway House Agreement. AIC Living Safely Without Violence Referral. The BOPP Preliminary Hearing Summary dated 2/27/26. BOPP Revocation Hearing Summary dated 6/3/25. Quest Diagnostics Lab Report and the Connection Resident Handbook Contraband List.
Thank you. You've also submitted an addendum to the parole violation report. Can you please review that for us?
Yes. The addendum reads, 6/23/26, Ms. Pina appeared in GA 23, New Haven Court under docket ending in 952-S for the criminal charges of 21A-279, possession of a controlled substance, first offense, and 53A-174, conveyance of unauthorized item into an institution. Ms. Pina pled guilty to the charges of 21A-267, use of drug paraphernalia, and was sentenced to unconditional discharge. There are no other pending criminal charges at this time.
Thank you. I do have a note, Officer Saunders. Can you just confirm, so the 2 charges against her were substituted just for that 1 charge? Or were
Correct.
nollies entered on them? Okay, substituted down.
Substituted down.
Thank you. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes,
I did receive an exhibit from the defense. I have exhibit 1, the list of parole accomplishments and future plans to a parole reinstatement. Counsel, do you need time to submit any other documents?
no,
We do not have any witnesses. So at this time, the state will have the opportunity to present evidence and speak to the evidence submitted and the charges presented before us. So Officer Saunders, any statements or comments right now towards the charges alone?
To the charges alone, I would say that the charges directly relate to what Ms. Pina struggles with, which is substance use. This is her 3rd violation, and as it relates to drug use, possession, and she just really struggles with that, and her motivation to attempt to get into seek treatment and help with that substance so it doesn't lead to illegal behavior. She really struggles with, and that's something her and I has spoken about continuously. That's all that I have.
Thank you. And counsel?
yes, thank you. In regards to charge 1 under obedience to the law, we would submit there's insufficient evidence to support a finding as to the conveyance of an unauthorized item into an institution, namely the halfway house that my client was placed in by parole is not a correctional facility per the statute, and thus does not meet the elements of the offense. In addition, the charge of possession of a controlled substance, we would note that the police report indicates that there was a field test done on residue, and that substance tested positive. However, there was no additional lab testings. In addition to that, the 2 pills that were listed are listed as unidentified. So we don't have any idea what those 2 pills were. So based on that, in regards to those 2 charges, we would submit there's insufficient evidence. My client did enter into a plea agreement in regards to the possession of paraphernalia and did receive that unconditional discharge. In regards to charge 2 under drugs, again, we would submit there's insufficient evidence for a finding. The charge indicates that on 5/12/26, 2026, my client rendered a positive urine for cocaine. I would just note that Exhibit N, which is a lab report, indicates that there was a toxicology sample given by my client, but not on 5/12 of 26. In addition, Exhibit E, an incident report from RISE halfway house program, does indicate that it was directed that a urine be collected. There's no indication that a urine was collected and that there were any results submitted as to a 5/12/26 urine results. So in that regard, we would submit there's insufficient evidence to support a finding. And again, in regards to the halfway house, just insofar as that my client was charged with criminal charges that were not substantiated, and that would be in regards to 2 identified pills, as well as conveyance of an illegal item into a halfway house or correctional facility. Nothing further as to the charges.
Thank you. Officer Saunders, any additional comments before I take a moment?
Well, as regards to charge 1, the state police officer is the one who pressed the charges, and she was arraigned under those charges, so I don't really have control or like much say about that charge. And as regards to charge number 3, the halfway house placement, the agreement is that she's to take prescription medication as directed. It's not, I didn't charge her with having any illegal drugs. It was just that she was in possession of medication, so she's to take them as directed if she's not taking them if she's in possession of them.
Thank you. Counsel, anything further?
I could just have one moment.
Yeah, no problem.
Just final comment in that regard is that the charge does not allege that my client was not taking her prescribed medication, and that's why my comments were as such. Thank you.
Yeah. So I'm just going to take a moment and then I will announce my findings. So on charge number 1, Ms. Peanut, I am finding that you violated the condition of obedience to the law. But, as testimony from P.O. Saunders was that the charges were substituted in court. You were arraigned on them to begin with, but they were changed by the prosecutor. So you did receive that unconditional discharge on 6/23/2026. In addition, the evidence in support of the charge states exhibits A, D, E, G, and H. I'm making a no finding on charge number 2, the condition of drugs, based on counsel's arguments today on the record. That a urine was not provided on 5/12/26 as stated in the notice of parole violation. And I am also finding that you violated charge number 3, the condition of halfway house placement based on the evidence presented in states exhibits A, D, E, G, I, J, and O. So it does conclude that finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history, and the state will also have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So Officer Saunders, anything about Ms. Pina's background history?
No, as stated earlier, this is her third violation since her release in 2024. She just returned off of a timeout violation for her drug use for failure to participate in treatment at the App Foundation. Sorry. I'm sorry, did you hear anything I said before?
I
Yeah.
got on to top. Yeah, I was.
Oh, okay.
We're still talking, but I did hear that she was just released from top.
Yeah, she was just released from top. And then when she returned to the halfway house from the timeout program, she wasn't engaged in any treatment or services that would help her stay in her recovery. That I gave her the opportunity to try to enroll on her own and independently. As referrals were made by the halfway house, she never had a chance to start in the program because of the continued use and the arrest. That's all I have.
Thank you. And counsel?
Yes, thank you. My client is 32 years of age. She's single. She has no children. She receives her primary support in the community by way of her aunts as well as siblings who reside in the New Britain area. She does have a high school diploma. She has completed some college. My client was experiencing many struggles clearly in the community. She does live with both mental health as well as substance abuse issues. She has a history of program participation and has been successful in the community when she's in a structured treatment environment. I will note that she was only in the community for approximately 1 month prior to relapsing. And so I would note that this is not a sufficient period of time to begin to engage in treatment. She does tell me that she reached out to her parole officer, who then made a referral for her to begin programming both relapse prevention groups as well as living safely without violence programming. However, she did not have an opportunity to begin that programming due to the arrest and thus remand. I would note that this violation, I would not characterize this as a third violation, noting that she did previously successfully complete the TOP program. So I would characterize this as a second violation. During the time that she was in the community, for the short period of time, she does report that she was in contact with the Emerge program and that she had completed an orientation prior to her remand. During the time period that she's been within the Department of Corrections, she indicates that she's been working with Project Genesis Reentry, which is an education program that's available that will help her with a reentry plan when she is released back into the community. I know her parole officer was recommending an 8-month period of confinement as a sanction, noting that she was charged with felony charges. And I would just note that she was incorrectly charged with felony charges. So she was not charged with felony charges. Felony charges were not pursued against her because they were she was incorrectly charged, and that was decided in court. So I think that's important to note. And again, I think it's important to note that it is not a third violation, it's a second violation. I think her violation is entirely based on a need for substance abuse treatment. She does have a substance abuse problem, and she's not arguing that she does not. That's something that she does have to address, and I don't know that remaining incarcerated is going to be a way to address that. The only way to address that is to be in the community and perhaps in inpatient programming or an intensive outpatient programming. So again, upon reinstatement to parole, she's asking to be placed in a halfway house, and the New Haven area would be her first choice. Second to that would be the Hartford area. She does have treatment goals. She would like to successfully complete an IOP with a step down to outpatient services, including medication management and individual psychotherapy. But she's agreeable to any treatment recommendations that are available to her. Certainly, she needs to have these programming set up for her immediately upon her release. Again, she was only in the community for a short period of time, and I know her parole officer has stated that there was nothing in place when she completed the TOP program, but I would submit to you that that's not necessarily completely her fault. She is on parole. She does require those services, and I think that something should have been in place for her when she was released to the halfway house. She's certainly amenable to it, but she does need a highly structured substance abuse program. So we would be asking that you take all of that into consideration, and a sanction not to exceed a 4-month period of time. She has been in custody now, I believe, since May 12th of 26. Thank you.
Thank you. Anything additional from either sides before I do announce my recommendation?
I'll just add, she's been offered and attempted to participate in inpatient, a highly structured inpatient services. There are time limits for how long she can stay there due to insurance reasons. So I think that should be taken into consideration as well. We can certainly get her back into inpatient, but there are time limits as to how long she can stay in those structured settings due to insurance reasons.
Thank you.
Am I allowed to speak?
That's
Or no?
council. It's your call.
Yeah, Brianna, if you have anything that you'd like to add, if you think that there's anything that you would like to add.
I do think my main issue is my substance abuse. I never come out of jail with a plan, and this time I've been working with Project Genesis to come out with an action plan. I have everything lined up for resources, for mental health, for job readiness, for financial literacy, everything in place moving forward. So I just would like to be given the opportunity to actually put this plan in motion.
Thank you.
Thank you. I appreciate your comments, Ms. Hina. Okay, one last time, anything further from any side before I take a second, before I announce the recommendation? Anything additional?
Nothing further from the defense.
Take a quick moment. So I have listened to the testimony today. I've reviewed all the evidence submitted. As council noted, this is your second violation. You did complete the top program as well as stated by both sides. With that, Ms. Pina, I'm going to recommend that your parole be revoked and that you serve an approximate 5-month period of confinement as a sanction. That's with a re-parole date of October 12th. I feel like is a holiday for some reason. So I'm going to go October 13th of 2026. And I'm going to recommend the following conditions. No consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with co-defendant Lauren Wolby, no contact with victim RS, general no contact with JH, mental health evaluation and treatment as deemed necessary, and halfway house placement. I just want to check that date because I know there's a holiday in October and we try not to do it. Staff's not in, it is on the 12th. So yeah, I'm going to keep the 13th. So October 13th. What happens next, Ms. Pina, is that my recommendation is going to go to the board on August 6th. On that date, the board can do 3 things. They can lower the recommendation to any day between August 6th and October 13th. They can adopt that recommendation if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back to address their questions and concerns before anything longer is imposed. So it does conclude today's hearing. Do you have any questions?
No.
Okay, thank you. Brianna, if you want to give me a call after the August 6th board review date, I can let you know what the board decided, okay?
Okay.
Okay.
Okay, thank you.
This
Thank
does
you.
conclude the revocation hearing for Brianna Pina, inmate number 386312. Good luck to you, Ms. Pina. Thank you, Officer
you.
Summers and Attorney Jones.
Bye,
Thank you.
Saunders.
Bye, Brianna.
Hey. Oh, you're muted over there.
Hello?
Hi, perfect.
Hi.
Awesome, thank you.
You're welcome.
Hi, good morning, Mr. Stella. How are you?
Morning.
I'm just gonna go check and see if your attorney's here, okay?
Alright.
Also, it is only 9:57 and we have to wait till exactly 10 o'clock anyway to start, so we have about 3 minutes, okay?
Okay.
Great. So we're gonna get started. So good morning, I'm Parole Officer Chiselle and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Juan Estella and inmate number 361519. Today is Friday, July 24th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Juan Estella, 361519.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Estella.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts. That's each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better weight of your evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. That recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Estella, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings, and if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Because you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I have.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We'll now review the charges that the state, your parole officers bring against you, and the information underlying each charge. So charge number 1, the condition of curfew. The charging officer reported that your PO had given you instructions to abide by your curfew from 9 p.m. to 6 a.m. and you violated your curfew times and you were aware of your curfew time. On 3/8/26 at 20 hours, East Hartford PD reported to 152 Arnold Street, East Hartford, Connecticut, regarding a dispute between you and the mother of your child. Victim reported that she picked you up from a friend's house because you were drinking and intoxicated. Once you were driven home, a verbal argument occurred between you and the victim. You then called Emily Valdez to get you a ride to her house in Bristol, Connecticut. You left the residence and East Hartford PD canvassed the area, and you were located at the Citgo gas station on Burnside Avenue, in East Hartford, Connecticut. Based on your behaviors, you are in violation of your special parole condition, release direction, curfew. Charge number 2, the condition of residence. The charging officer reported that you did not notify your parole officer that you had moved, and you did not have permission from your parole officer to reside in any other address. Your only approved address for parole is 168 West Street in New Britain. On 3/8/26 at 20 hours. What am I saying? Hours. East Hartford PD reported to 152 Arnold Street in East Hartford regarding a dispute between you and the mother of your child. Victim reported that she picked you up from a friend's house because you were drunk, you were drinking and intoxicated. Once you were driven home, a verbal argument occurred between you and the victim. You called the other baby mother, Emily Valdez, to get you a ride to her home in Bristol, Connecticut. You left the house, and later that morning, East Hartford PD canvassed the area, and you were located at the Citgo gas station on Burnside Avenue, East Hartford, Connecticut. Also, it was reported that James Harris, stepfather of the victim, later came to East Hartford PD and reported he would like you, Stella, out of the property because you have been staying there for a week and want to avoid further problems. Based on your behaviors, you are in violation of your special parole condition, release direction, residence. Charge number 3, the condition would be against the law. The charging officer reported that on 3/8/26 at 20 hours, East Hartford. I didn't say that wrong, right? What I should say that? 20 hours. I think so. East Hartford PD reported to 152 Arnold Street in East Hartford, Connecticut, regarding a dispute between you and your mother and the mother of your child. Victim reported that she picked you up from a friend's house because you were drinking and intoxicated. Once you were driven home, a verbal argument occurred between you and the victim. You then hit her in the chest and threatened to hit her again and continued to be argumentative. You then began to choke her and then released her, at which point she told you to leave. You then charged at her and continued to hit her, causing her to have scratches on her chest and ripped her t-shirt. She was able to get you off and called her mother, and she then called East Hartford PD. You then called Emily Valdez to get you a ride to her house in Bristol, Connecticut. You left the residence and East Hartford PD canvassed the area, and you were located at the Citgo gas station on Burnside Avenue in East Hartford. Officers reported that you appeared to be intoxicated and could smell the aroma of alcohol emanating from your body. Based on the facts and circumstances, you were arrested and charged with Connecticut General Statute 53A-64 CC, strangulation third, 53A-61 assault third, and 53A-182 disorderly conduct. Based on your behavior, you are in violation of your special parole condition of obey all laws, obedience to the law. Charge number 4, condition of drugs. The charging officer reported that on 2/10/26, you rendered a positive urinalysis and signed a voluntary admission form admitted to using cocaine on 2/8/26. Per your special parole condition, you acknowledge that you will not use or have in your possession or control any illegal drug, narcotic, or drug paraphernalia. Based on your behavior, you are in violation of your special parole condition, obey all laws, drugs. And charge number 5, the condition of alcohol consumption. The charging officer reported that per your special parole conditions, You were prohibited from the consumption of alcoholic beverages. On 3/8/26 at 020 hours, East Hartford PD reported to 152 Arnold Street, East Hartford, Connecticut, regarding a dispute between you and the mother of your child. She, the victim, reported that she picked you up from a friend's house because you were drinking and intoxicated. Once you were driven home, a verbal argument occurred between you and the victim. You left the residence and the East Hartford PD canvassed the area, and you were located at the Citgo gas station on Brinson Avenue in East Hartford. Officers reported that you appeared to be intoxicated and could smell the aroma of alcohol emanating from your body. Based on your behavior, you were in violation of special parole condition and additional conditions of alcoholic beverage consumption. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the conditions of parole. Exhibit B, the remand for custody. Exhibit C, the parole violation report. Exhibit D, the notice of parole violation. Exhibit E, the East Hartford PD case number 26-00007439. Exhibit F, misconduct. Exhibit G, the voluntary admission form. In addition, the state did file an addendum to the parole violation report on July 8th that reads that on May 29th, the subject, Wanasella number 361519 was seen in GA 12 Manchester regarding to docket ending in 476S, and the dispositions are as followed. The strangulation, suffocation third degree was nollie, the assault third was nollie, and you were convicted of disorderly conduct and received a 45-day jail sentence for that charge. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
Perfect. I did receive 2 exhibits from the defense. I have Exhibit 1, the list of parole accomplishments and future plans for parole statement, as well as Exhibit 2, a support letter from Emily Adorno. Counsel, do you need time to submit any other documents?
I do not.
You don't have any witnesses. So at this time is the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Thank you. With regard to the first charge, the curfew violation, I didn't see any evidence submitted that indicates there was a curfew condition imposed. Normally, the curfew condition is imposed with GPS supervision, and there was no GPS condition submitted as an exhibit, and Mr. Estelle indicates he was not on GPS supervision. So I would argue there should be no finding on charge 1. With regard to charge 2, I would also argue there's insufficient evidence to establish he moved out of his residence in New Britain. There was no evidence presented that his personal items were no longer there. There was no evidence from his sponsor that he had moved out. The only evidence presented was a hearsay statement from one individual that he had been in East Hartford for a week. That's not sufficient to establish he moved out of New Britain without the intent to reside there any longer. With regard to the new charge, he was convicted in court of disorderly conduct, a Class C misdemeanor. All the charges against him were misdemeanor in nature, but the 8 misdemeanors were nollied by the court. He now has completed that 45-day sentence that was imposed. If there is a finding, I would like to hear further with regard to the sanction. Thank you.
Thank you. So, Mr. Estelle, I am going to announce my findings now. So on charge number 1, the condition of curfew, I'm making a no finding as the state failed to submit sufficient evidence to support the charge. Therefore, the elements were not met. On charge number 2, the condition of residence, I'm also making a no finding. Again, the state failed to submit sufficient evidence in support of that charge, and the elements of that condition were not met. On charge number 3, I am finding you violated the condition of obedience to the law based on your conviction of a disorderly conduct when you received that 45-day jail sentence on May 29, 2026. And in addition, the evidence in support of that charge is states exhibits A, C, and E. I am finding that you violated the condition, charge number 4, the condition of drugs based on the evidence presented in states exhibits A, C, F, and G. And lastly, for charge number 5, the condition of consumption of alcoholic beverages, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge, and therefore the elements were not met. So it does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak your background and history. The purpose of this part of the revocation is to help determine what outcome I recommend. So, counsel?
Thank you. So Mr. Estelle, he's 34 years old. He was born and raised in Connecticut with his family. He has a large family. They still reside in the Bristol and New Britain area. They provide him with a lot of support. He's close with them. It consists of his parents, his brothers and sisters, and he has 3 children, including a young baby. He does have a good relationship with his children. He is looking forward to the opportunity to be with them again when he is released. A letter of support was also provided from Ms. Adorno as well. which does provide some additional perspective on a lot of the strides Mr. Estella has been taking and some of his goals for the future. When he is released, Mr. Estella is looking to be sponsored by his girlfriend's grandmother, who does reside in Bristol, and her information was provided in the mitigation report, with a halfway house in Hartford as a backup plan if for some reason the Bristol sponsor is not approved by Parole. Mr. Estella, he did complete his GED. He has some credits for college he took while he was incarcerated. In the future, he would like to return to school, complete his degree, and graduate from college. He was employed before he was remanded, and he was working consistently for a period of time. His mitigation report also outlines his what I consider a pretty strong employment history. Recently, before his remand, he was employed at Pizzuto's in New Haven for about 15 months. He did get a job as a flagger, which he was working for about 3 months before he was remanded. And he was working there at the time that he was remanded. He did complete a flagger certification program, and he does indicate that position will be available to him again when he's released from incarceration. So he doesn't plan to go back to work when he is released. He has been under supervision for over 2.5 years since his last incarceration at the time of the remand. I do feel this fairly extended period of supervision without a violation does demonstrate a willingness and ability to work positively with Parole and engage in the treatment recommendations that they're requiring of him. The only graduated intervention listed in the PBR was that one positive drug test in February 2026, which was a basis for this violation. After that one test, he was referred to additional substance use treatment, and he did cooperate with that. Other than that, it appears he's been doing very well under supervision, complying with the treatment recommendations and all of his parole obligations. He's completed multiple treatment programs while on parole. He's worked with MCCA, the Wheeler Clinic. He's worked with Connecticut Renaissance. I think he's demonstrated a good track record, and he does intend to continue that when he is released. Mr. Estella's parole officer was recommending that he complete any imposed sentence on the new offense and comply with the condition of no contact with the complainant. In this case, that 45-day sentence for displayed conduct has been completed. As I indicated, he's certainly willing to abide by any treatment or supervision conditions parole thinks is appropriate based upon this most recent conviction. I would ask that Mr. Estella be released at the next available date. I think the length of time he's been under supervision, as well as the fact that he was only convicted of one Class C misdemeanor, he was never charged with any felonies, should be taken into consideration here by the board. He has a plan in place to get back to work, to reconnect with his family. He wants to see his baby and bond with his new baby, and he's certainly going to continue working with Parole and abide by any type of additional treatment recommendations. Mr. Estella, is there anything you'd like to add?
Yes. I have, before this, there was, when I believe it was 2023, the last time I was incarcerated. Before that, it was years before I ever got in trouble with the law. This would be the first time technically I have gotten in trouble with the law. I've learned my lesson. I'm really ready to continue. I want to get rid of the rest of this special parole and abide by any rules that I have to. Like, I'm ready to go back to work. It's been a substantial amount of time that I've been away, so I really don't want to lose my opportunity of having that job. And I just had a newborn. Like, I just had a son, so I don't want to waste any more time being incarcerated. And Peter, thank you for saying everything.
Thank you, Mr. Estella.
Thank you, Mr. Estelle. Thank you, counsel. Before I make my recommendation, I don't have, what was the victim of this incident?
It's not
No. Them?
No.
Is it ES?
Yes.
What are the initial, that's the victim that identified as ES?
Yes.
Okay. And do you have children with ES?
Yes, I have.
Okay. And that's not the newborn baby though, correct?
No.
You have just other children with ES?
Yes.
All right, I'm just gonna confirm one more time. And then the sponsor you've asked for is not related to ES?
No.
Okay, that's someone else. Okay, perfect. All right, so I have listened to the testimony today and I've reviewed the evidence, Mr. Stella. With that, I'm gonna recommend that your parole be revoked and that you serve an approximate 5-month period of confinement as a sanction. That's with the reparole date of August 7th, 2026. I'm gonna recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with co-defendant Eric Morin, general no contact with ES without parole officer's permission. Mental health evaluation and treatment as deemed necessary, and I will note the sponsor information for you. So what happens next, Mr. Stella, is that my recommendation is going to go to the board on August 6th. So on that day, the board can do 3 things. They can actually release you that day if they choose to do so, but I'm recommending the following day. They can adopt my recommendation if they choose to do so. And then if for any reason they would want to see a period of confinement longer than what I've recommended, they'll ask you to come back for another hearing to address any questions and concerns before anything longer is imposed. So it does conclude today's hearing. Do you have any questions?
Yes, I do actually have, so for this, for me being on special parole, the controlling charge is what, may I ask? Because I feel like it's been over a decade.
There was several charges, there were a couple consecutive sentences. There was a burglary, third, a larceny, there was stealing a firearm.
It ends in August of
Yeah,
2027.
you have about a year left.
Right, so then the sentence for that was 3.5 years and 5 years special parole. That was in 2016. We're in 2026, that's 10 years.
There was a 2-year consecutive, I think, on a burglary. And then some of those sentences were consecutive, but according to the calculations, if you think it's wrong, you'd have to contact your attorney in court and they could try to file a motion, but from what we have, it shows it's maxed out in August of 2027.
That's
Okay.
including absconder time. Did you abscond in the past?
Yes, but at the same time, I was remanded, and then I also I hit max out. I ended my sentence incarcerated and was released, and my special parole never started. So that's 10 years from the last time I was convicted of this.
Yeah, so it does, I have that your special parole started on June 24th, 2022, and it ends on August 18th, 2027, and that's including any the absconder time that was added, because when you abscond, it doesn't just go away, it's added to the time.
No, correct, but there was no way I absconded for 2 years.
But the board's not gonna address that. If that's an issue, you'd have to deal with that in court.
Okay, thank you, Peter.
So on August 6th, I'll make the decision, okay?
All right.
All right, so this does conclude the revocation hearing for Juan Estella, inmate number 361519. Good luck to you, Mr. Estella.
Thank you. Have a good morning.
Good morning.
Speak. She can hear. Can you hear?
Yes, we can hear you. Thank you.
You're welcome.
Good morning, Mr. Wright. How are you?
Morning.
Morning. So it's 10:28. We cannot get started till exactly 10:30, so we'll start in 2 minutes, okay?
Okay.
Thanks, you too. Sure. 10:30. Just wait right there. Loud. 33, please. Thank you. 3156, or any of it'll go over. I have one more.
So we're gonna get started. So good morning, I'm parole officer Giselle, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Taiwan Wright, inmate number 364261. Today is Friday, July 24th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Taiwan Wright, 364261.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Wright.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Wright, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
So you do have important rights, and I am going to review them with you now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I am.
We'll now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So charge number one, the condition of GPS. The charging officer reported that on 2/19/2026 due to the offender not charging his GPS unit as directed for 2 hours a day. The GPS unit shut down at 9:55 p.m. until 10:18 p.m. On 2/20/2026, due to the offender not charging his GPS or the GPS unit as directed for 2 hours a day, The GPS unit shut down from 3:18 a.m. to 9:00 a.m. On 3/12/2026, due to the offender not charging the GPS unit as directed, for 2 hours per day, the offender's GPS unit is shut down from 10:09 a.m. till 10:53 a.m. On 3/17/2026, due to the offender not charging the GPS unit as directed, for 2 hours per day, the offender's GPS unit is shut down from 7:02 a.m. to 9:43 a.m. On 4/17/26, due to the offender not charging the GPS unit as directed for 2 hours per day from 2:15 p.m. until 4/18/26 at 4:11 p.m., the offender's GPS unit shut down. On 6/11/26, the offender charged his GPS unit for 29 minutes, which led to the offender's GPS unit shut down on 6/12/26 from 2:05 a.m. until 6:55 a.m. On 6/29/26, the offender failed to charge the GPS unit, which led to the offender's GPS unit shutting down on 6/30/26 from 3:30 a.m. until 7:26 a.m. Charge number 2, the condition of halfway house placement. The charging officer reported that on 2/8/2026, the offender returned to the halfway house from on pass to church, at which time he tried to conceal having $1,000 in his possession. The money was seized by the halfway house staff, at which time the offender took the money from the staff member's hand and left the program without authorization. The offender returned to the program a few minutes later and gave the staff member the money. This is in violation of the halfway house agreement, which states, "I will not leave the physical confines of the halfway house unless authorized by program staff or parole, and I will not have more than $50 in my possession without proper permission. If I need to withdraw a larger sum of money, I'll make a request in advance to program staff and/or parole." On 3/9/2026, the offender was instructed to complete halfway house chores 3 times. The offender failed to do his chores. The offender was instructed he needs to follow the rules of the halfway house. This violates the halfway house handbook, which states failure to complete housekeeping assignments is a Class D violation. On 5/1/2026, the offender was due back at the halfway house from Wheeler Clinic at 2:45 p.m. The offender did not return until 3:15 p.m. The offender failed to answer the phone, any phone calls. The offender was unaccountable in the community for 30 minutes. This violates the halfway house agreement, which states, "I will return to the halfway house with my community pass at my scheduled return time. If I'm unable to do so, I will call program staff to explain why I am expected to be late and receive a new return time." On 5/16/26 at 11 a.m., the offender was seen on the camera by halfway house staff, RRS Sean Brown and RRS Ruben, walking in room number 42 and number 32. RRS staff instructed the offender to report to the main office in the halfway house, and the offender refused. RRS Ruben walked to room number 28 and instructed the offender he is not allowed to be in other offenders' rooms. On 5/16/26 at 11:37 a.m., the offender was seen again walking in and out of room number 32. This is in violation of halfway house handbook, which states being in an unauthorized area is a Class D violation. And on 7/4/2026, the offender was issued a community pass for work with a return time of 12:25 a.m. The offender returned to the program at 2:38 a.m. on 7/5/26. On 7/5/2026, the offender ordered an Uber at 12:00 a.m. to transfer him from work to 598 Farmington Avenue in Hartford, Connecticut, which was not the authorized location. This is in violation of the halfway house agreement, which states that I will only go to locations indicated on an approved community pass unless changes have been authorized by staff, and I will return from the halfway house from community pass at my scheduled return time. The state has filed the following exhibits that have been marked for identification purposes. As Exhibit A, the conditions of parole. Exhibit B, the notice of parole violation. Exhibit C, the parole violation report. Exhibit D, the remand to custody. Exhibit E, the halfway house agreement. Exhibit F, the GPS monitoring agreement. Exhibit G, the offender charge history. Exhibit H, the misconducts. Exhibit I, the halfway house incident report. Exhibit J, the community pass. Exhibit K, the residential discipline reports. Exhibit L, the pictures. Exhibit M, the disc. Exhibit N, the halfway house handbook. Exhibit O, the halfway house handbook receipt. And Exhibit P, the SO evaluation. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes,
All right, and I have not received anything from the defense at this time. Do you need time to submit any documents, counsel?
not this time, no.
All right, we don't have witnesses. So at this time, it's the defense's opportunity to respond, make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So, counsel?
Thank you. I'd like to ask Mr. Wright a few questions.
Sure.
So, Mr. Wright, with regard to the GPS unit, did you have any issues keeping this unit charged properly?
Absolutely, and I notified my counselor about the difficulties I was having with the GPS monitoring system that was on my ankle. I repeatedly told my counselor about these issues I was having. I asked her to notify my parole officer about those difficulties.
Okay, so the problem was it wasn't holding a charge? Is that what the issue was?
Was that an answer?
No, that wasn't an answer. My
Okay.
answer is I'm not a computer geek, but I know there was some kind of malfunction with the GPS. I know I was charging it, and when I plug my charger in, it would tell me that it's not charging. So I don't know how to answer your question. I just know
That's
something.
okay, I understand. Basically, you were attempting to charge it and you were having issues and it wasn't charging properly. Is that correct?
Yeah, that's correct.
Okay, so turning to the halfway house, with regard to March 8th and the chores, you were, well, I understand you had some issues with the condition of the bathroom that day. Is that correct?
I'm not sure if it was specifically that day, but I know there was an issue associated with the bathroom. For an example, if I cleaned the bathroom, there was a client in a halfway house, we don't know who it was, but they'll go inside of the bathroom and urinate all over the bathroom, defecate all over the bathroom. Like, that was an issue. So that was like,
Oh, that was the concern you had. You went to the bathroom and there was feces and urine all over the place. Is that correct?
absolutely.
Okay. So, turning to May 1st, when you went to the Wheeler Clinic. Now, on that day, you did go directly to and from your treatment on that day. Is that correct?
That's correct.
And you were on GPS that time?
That's correct.
And the GPS wouldn't show that you were anywhere other than when you were supposed to be. Is that correct?
That's correct.
All right. And you were approximately half an hour late returning, and was that due to public transportation?
That's correct.
It just took you longer to get back than they wanted because you had to rely on the bus. Is that accurate?
That's correct.
Okay. Turning to 5/16, on this date, they're alleging you went into 2 rooms. It's my understanding you were looking for cleaning supplies. Is that accurate?
That's correct. The halfway house, it was the cleaning was maintained by the clients, and this particular halfway house wasn't that clean. So what the clients do is hold the cleaning supplies in their rooms, and sometimes when your cleaning supplies run out, you'll have to find somebody who will let you use the cleaning supplies that they're holding in their room. So when you see me going from room to room, I'm attempting to find cleaning supplies. So that my ticket associated with me being in somebody else's room is trying to find cleaning supplies.
All right, thank you. So, and then finally, with regard to July 5th, when you were coming back to work, what happened with the Uber ride on that date?
That particular day, I was scheduled to work for 4 hours. When I got to work, one of my shift managers asked me to stay longer. So I told her that I was in a halfway house and I can't just stay if I want to, that I have to contact the halfway house. So she told me to contact the halfway house. The halfway house verified my hours and I was able to stay longer than the 4 hours I was scheduled for. So after my hours to stay longer was verified, I went to a different shift manager and I told her I just got out of prison. I'm not tech savvy and I need help booking an Uber ride back to the halfway house. She said she would help me. So I said, is it a good idea? I don't remember the time. I know it was early. I think it was like 5 o'clock. And I was scheduled to leave at 1 o'clock in the morning. So I asked her, is it a good idea to book the Uber now or closer to when I get off a shift? So she said, contact her when it's closer to get off of a shift and I need the Uber. So that's exactly what I did. We downloaded the app. She handed me the phone back. I put 21 Cliff Street in, Waterbury. I gave her the phone. She booked the ride. Me and her seen the same thing on the screen. I can't explain what happened. I do not know what happened. The Uber came. I jumped in the car. I was also in the middle of getting my license, so I was paying attention to where we were going because I wanted to know how to get back to Waterbury from my place of employment. So I asked the Uber driver where we were. He told me we was in West Hartford. I was confused because I know West Hartford is in the opposite direction of Waterbury. So I asked him, why are we in West Hartford? So he pulled his phone out. He showed me the destination and it wasn't 21 Cliff Street. So I jumped out of the Uber and I immediately called the halfway house and let them know what was going on. My phone was dead. I wasn't prepared to stay that long, so my phone was dying. I ended up ordering another Uber ride, and I eventually got back to the halfway house.
All right. Thank you for explaining what happened, Mr. Wright. So with regard to these allegations, he did indicate he had some issues charged with the GPS. He did make efforts to try to get this remedied, but he did have trouble keeping it charged. With regard to the halfway house violations, there's a few incidents alleged here. With regard to turning over the money, it's alleged Mr. Wright was initially hesitant to turn over the money to the halfway house, but pretty quickly he did comply with that regulation. They said he was back in a few minutes and he did turn over the money. He's not been charged with any crime related to this money. The basis of the violation is that he's not allowed to have $150 cash in his person, and he did ultimately comply with that requirement. In none of these violations is there an allegation that he was rude, violent, confrontational, fighting with other residents, or fighting with staff. Apparently, I know he was a little upset with regard to the money, with regard to the state of the bathroom, but there's no allegation he was ever yelling at anybody or being rude or using offensive language or anything like that. There are some other allegations in the narrative about convicting people from jail and possibly making some potential admissions with regard to other conduct, but those are not included in these charges, and those shouldn't be taken into consideration with regard to what the alleged violations are here today. There's no allegation here that Mr. Wright engaged in any type of criminal conduct. The only allegations here are GPS issues and complying with some of the halfway house rules. I would also note with regard to the uncharged conduct regarding marijuana, Connecticut General Statute 54-125K, requires that marijuana use or possession should not be a basis to violate an individual's parole unless there's specific circumstances which aren't the case here. So if there is a finding on either of these charges, I would argue the particular allegations are not serious enough to warrant revocation. He's certainly willing to continue working with parole, complying with the halfway house, and I would ask that he has that opportunity. Thank you.
Thank you. So I'm going to announce my findings now, Mr. Wright. So on charge number 1, the condition of GPS, I am making a finding of probable cause based on the evidence presented in States Exhibits A, C, F, and H. I'm also making a finding of probable cause for the charge number 2, the condition of halfway house placement based on the evidence presented in States Exhibits A, C, E, H, I, K, N, and O. I am also going to find that the acts are serious enough to warrant revocation, and I've also determined that it should be detained while you await that revocation hearing. So what happens next, Mr. Wright, is that we will schedule a revocation hearing for you within 60 business days of your remand to custody. At that hearing, a revocation office, another revocation hearing examiner or myself will determine if you violated the conditions of your parole. And if so, that hearing examiner will make a recommendation whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Any questions at this point, Mr. Wright?
No questions.
So, Mr. Wright, I'll be in touch with you and my social worker will be in touch with you to prepare for the revocation hearing, okay?
All right.
All right, we'll see you in a few weeks, okay, Mr. Wright?
All right, see you in a few weeks.
All right, this concludes the revocation, the preliminary hearing for Taiwan Wright in number 364261. All right, we'll let you know when you have that hearing scheduled, okay?
All right,
All right, have a good day.
you too.
Good morning. Today is Friday, July 24th, 2026. I'm going on the record to state that the case for Tyrone Tyson, inmate number 183722, is not going forward as his attorney has waived the hearing. So that hearing will not be heard today based on the waiver received by counsel. Thank you.